Life's Third Act. Here's attorney CPA Joe Cordell.
Welcome to another episode of Life's Third Act. This is a little different today. We felt it was fitting. I mean, this is Halloween after all.
Halloween Eve.
Yes. So we thought that we wanted to do a show that not only had material that we feel ties in with the subject, which we'll talk about in a second, but we also wanted to do a show in a way that had more interaction, more engagement. And we kind of feel like the format that we use when we don't have a live show is a little stiff in terms of what we would like it to be. We would like to have more comments from you guys. We'd like to have more kind of participation in the show, for lack of a better way to put it. And we thought, well, what better time than Halloween is an occasion that is fitting for the topic of this show, which is death and estate planning. But also it's an occasion when we'll go ahead and try something different. This is the first time we've ever done live.
Yeah. I mean, I guess you could say it's fun. As fun as you can get about talking about murder.
Well,
right?
Yeah.
The possibility.
We know
allegedly.
that this is a subject of great interest, voyeuristic interest perhaps, but still interest. So the topic today, Lizzie Borden. Now, I don't think I need to explain to you who Lizzie Borden is, but there probably are a few of you who may be perhaps so young that you've not heard about Lizzie Borden. But from the standpoint of what this show's about, which is estate planning, and what can we learn from people's estates, we think it's also fitting that we also deal with a topic that ties in with that in a memorable way. So I clearly think that Lizzie Borden was a memorable case involving the death of her parents, for which she was tried, and we're going to talk in more detail about that. But our main focus for doing this show and topic, like is always the case, is that we want to come from a little different angle, not the standpoint of biographers or historians who talk about the facts of the person's life and even the facts about the death, but really talk about what often is not covered. And that's the very interesting things about what happens with probate and estate planning and assets after people die, which are often, the moving force, we'll say, behind what ultimately happens. So I don't want to be so cynical about why death and mayhem occurs, but often it is about money.
Yes.
And often that money comes in the form of estate inheritance. So, or at least goals.
And how you really have to have things planned out, especially if you have a blended family. And this is a perfect example for that.
Ah, yes. The modern blended family. So it existed in the 1890s too. So why don't I hand it over to you?
Okay.
Let's go ahead and talk about the life, and we'll come to our main topic shortly.
All right. Well, Lizzie Borden, like you said, she's a very popular person. There's been several films, even if you want to do a little bit more digging. There's The Legend of Lizzie Borden, 1975, Lizzie 2018. There's also one in production right now on Netflix, Monster, The Legend of Lizzie Borden. So be on the lookout for that.
It is taking a position when you name it a monster. I mean, because, she was found not guilty, not to spoil it for many of you who don't know. But anyway,
there's a lot of wonder.
So, but the fact that Netflix would be doing a movie production on this topic, again, a topic that's been done multiple times, tells us that there's this enduring interest in this story.
Because a woman is involved, or possibly involved, in a murder back then. They didn't think a woman had it in her to do such a thing.
That may have been a factor.
I have a feeling.
In the acquittal.
Yeah.
So tell us about Lizzie Borden.
So Lizzie was born July 19th, 1860. And her dad, Andrew Jackson Borden, and he was a self-made businessman and property developer in Fall River, Massachusetts. Her mother, Sarah Anthony Morris Borden, she sadly passed away when Lizzie was only 2 years old. So, Lizzie went without, her mother. but she did get a stepmother right away. Just about 2 years later, Dad remarried an Abby Durfee Gray Borden. Now, Lizzie also has a sister, Emma Lorena Borden, and she was 9 years older. So she would have been a teenager when Dad got remarried. So they kind of went back and forth with how the family lived, because Dad, he had some money, but Dad wasn't always willing to spend the money. So the
He was a
girls,
very frugal sort of
yes,
guy.
he kept that purse pretty tight, or the wallet tight. But
He's also a little puritanical, but we'll talk a little bit more about that. Go ahead.
well, they did go to church a lot, and they were, did the things as they were growing up, their childhood, strict religious household, but there were some tension between the sisters and the stepmother, which I know we talk a lot about stepmothers here. But education and church life, they attended those local schools, became deeply involved in the church, teaching even Sunday school, participating in women's Christians union groups. And well,
Yep.
something happened though.
Well, wait,
Something.
but to clarify this, I mean, Lizzie
Mhm.
Borden had been active in the church
Yes.
herself and
Mhm.
had taught Sunday school.
Mhm.
And so she seemed to be a true
Yeah.
believer in terms of her faith. But let me pause here also, and before we talk about the murders, that the father was, I don't want to stereotype him too much, but he was one of these stern, we don't know the religious denomination, we couldn't find that out,
Mhm.
but maybe Presbyterian, not to pick on Presbyterians, but anyway, and I think that he was so frugal to the point that he was almost Spartan. They had few, if any, full-time. I didn't read about any full-time domestic help, which,
Mhm.
given their net worth at the time, that's something you would commonly see. Now, they had people that came and worked. There's a lady
Mhm.
that came and cleaned periodically, and perhaps someone who worked on the exterior of the house. But it would have been appropriate at that time for a family such as this to have full-time domestic servants. Unlike our world, it was very affordable.
Mhm. And speaking of that family, I mean, they were a prominent family. They had Simon Borden. He was an engineer and or the surveyor who built Massachusetts' first site map. They also, Nathaniel Briggs Borden. He was a U.S. congressman and mayor of Fall River, which, that's where they were all living. So there was a lot
Yeah.
of popularity, I'm sure, and influence in that family. And then Gail Borden was the inventor of condensed milk and founder of Borden Dairy, was a distant cousin, which, of course, Borden Dairy, Borden cheese. You see
Yeah.
them at grocery stores still today. But so the family, I mean, they were very well known.
Yeah, and the father, his net worth was around 300,000 at the time, which it's easy for us to lose sight of how much money that is
Yeah.
in that day.
I think I read somewhere that would be like 10 million today.
Yeah, and I even think that's low as a
Mhm.
multiple, because you think about what inflation does in terms of cost of
Mhm.
living, and so many things change so dramatically. For example, if you were to say that a representative multiple would be what people earned at the time versus now,
Mhm.
you'd be way past $10 million. For example, a wage earner at the time might be 50 cents an hour,
Mhm.
give or take. And now, what, 20, depending on the
Yeah.
union, if it's union 30. But so we're not talking about so much minimum wage. We're talking about what would be a representative wage.
Mhm.
And so today, a representative wage would not be the minimum wage. And
Mhm.
so if you did those multiples, you can clearly see you end up more than substantially above $10 million. So it was a big estate, is the
Yes.
point. He was considered wealthy at the
Mhm.
time. I'm sure one of the wealthiest men in the area.
But it sounded like the girls, I guess, growing up, they didn't have the same things as other wealthy girls in the neighborhood did.
No, they lived, in this very almost Spartan,
Yeah.
but it was the philosophy of their father,
Mhm.
and it's hard to know what his personality is like, but he's been presented by history as somebody who was aloof and stern, and perhaps disapproving of many of the things that women would have wanted, daughters that
Yeah.
age would have wanted to do at that time.
Mhm. I mean, even that's the same with today's daughters, I think.
Yeah.
You know,
Well,
not much has changed. You want the
no.
high fashion, you want this, you want that, and dad, no, no, no.
Yeah.
So, but that's kind of how the girls were raised, very strict. And from record in 1887, by that time, Abby, Abby, the stepmother, the girls stopped calling her mother.
Was it both daughters or was it
At
Lizzie?
least Lizzie.
Yeah, because I'd read that Lizzie did,
Mhm.
and I think there was a difference between these two daughters in the way that they regarded their stepmom.
Well, they were such different ages when they had a
Exactly.
stepmother. You've
And
got a
that's a good point.
4-year-old and like a 13-year-old. So
Yeah, yeah, that's a very good point, and because it seems that Lizzie had more of the conflict.
Mhm.
Um,
She
and
was the
something,
baby.
not jumping too far ahead, but the fact that after this murder trial and the acquittal of Lizzie, that her sister and she became estranged after that.
Mhm.
It's almost as if the sister wasn't willing to abandon her during the trial, because she was her sister.
Yeah.
And so she kept quiet. But then as soon as the trial's over and she's acquitted, it's like they go in two different directions. They never live together again.
Yeah, you wonder
Yeah,
what
you
happened
just,
there.
yeah. And the sister probably having the family loyalties that she had, no one knows of her sister ever saying, I couldn't find anything where her sister had later given an interview and said that she
Yeah.
thought that, and by her sister, we're talking about Emma.
Mhm.
So Emma there's no evidence she gave an interview in which she accused Lizzie of murder. So,
Mhm. And both sisters, neither one married.
yeah, and neither
So
had kids.
mm-mm.
So just an interesting scenario, the whole family. So continue on. So do we come to the murder at this stage?
Well, just about we have the pigeon incident. So
Oh.
Lizzie apparently was very upset with her father because she had pet pigeons. And I guess maybe he tired of them and he ended up killing these pigeons. And some think that that could have been a point that really upset her, and a hatchet was used.
Yeah. That's a bizarre incident. We don't know a lot about it, but it was part of the testimony at the trial.
Mhm.
And there was testimony that suggested that Lizzie had some strange incidents in her life, and she seemed to have perhaps some psychological instability. She was much more expressive and would get upset about things. That there were allegations that she had a problem with kleptomania.
Mhm.
And in the town where everyone knew how wealthy the family was, and of course they knew that any merchant who had something small that disappeared with Lizzie would be paid. So there were never charges to support these occurrences, but clearly she had this background that of some, for lack of a better word, just some instability.
Yeah.
Psychological
The
instability.
things she wanted that dad wouldn't buy, she just took. Basically.
Well, I don't know about that. And that's the whole
Maybe.
idea is it because she just took it, or more likely, she just had psychiatric issues, and that she lived in a day where it wouldn't have been easily diagnosed. But also, not speaking entirely chronologically here, but wanting to emphasize creating this picture correctly, she didn't come apart in the rest of her life. So, it is interesting, and it does suggest something closer to the sort of coldly rational premeditation, because you would expect if there were serious psychiatric problems, it would have appeared during the rest of her life. And the rest of her life appeared to be pretty stable. She managed her money very effectively, et cetera. So this is all said to give you a fuller picture of Lizzie Borden going into this trial. So
Well,
tell
she was
us
very
what happened.
calm. She was very calm, like you're saying, like during the trial, even
Yeah.
during as the investigators were there at the house. So what had happened, August 4th, 1892, Andrew and Abby Borden, they were found brutally killed with a hatchet in their home. Now, at the time, Lizzie was still living with mom and dad at the age of 32. She claimed that she was in the barn when these murders happened. And I believe one of the other stories that I had read about her was that she had gone to a neighbor's house to say, my dad's been murdered.
This
Okay.
is after she found them.
After she found them.
Where was I couldn't find where Emma was.
Yeah, I never found that out either. Where sister was. I just
But
knew
apparently
where-
she was clearly had an alibi. Perhaps she was
Yes.
out of town.
Mhm.
Perhaps she was in town and
Mhm.
not at the house.
Yeah, I think they even had a family member, a distant relative visiting, but they were even out of the house at the time that all that went down.
Okay, so the only person that was on the property at the time, it seems, other than the killers,
Yeah.
whether or not that included Lizzie.
Mhm.
So she, her position was she was in the barn.
Yes, in the barn. And well, it took a while. They did a lot of investigations. They figured out that the stepmother was upstairs in the bedroom. That's where they found her. And her body was already cold. Now, when they found dad, he was on a couch in the downstairs, yeah, on the main floor. And he was still, I believe, warm.
Well, there was a difference in body temperature.
Yes.
And this is important. We'll talk about in a second. But they were trying to determine order of death.
Yes.
And how did this crime take place.
Mhm.
And the consensus was, though not unanimous, but the consensus was that Lizzie went upstairs, killed the stepmother, and then came down and killed her dad. And I guess it was sufficiently far apart that it couldn't have been just 2 minutes apart, 3 minutes apart, 5 minutes apart, which you could easily imagine happens upstairs, runs downstairs, kills the dad. Apparently there was enough of a lapse in time to create this difference in how stiff, rigor mortis, whatever, had how stiff the bodies were, in addition to the body temperatures.
Yes.
So, and this is primitive. This is at a time when we don't have forensic science.
Way before CSI.
Yeah, right. It's not that, but it was evident to the expert, I guess the examiner, that is who they call this person at the time, who did the physical and who did the autopsy, etc. And his determination was that clearly the stepmom died first. So if it happened in that order, that's going to have some consequences for what occurred later. But also occurring in that order, the prosecution, interpreted this to mean that the main conflict was with stepmom, and that because stepmom died, she had to go down and kill stepdad or still kill dad. But then there was at the trial, there was another motive for which there was testimony. And that's that there had been talk about their dad, Andrew, deciding that he wants to prepare a will. There wasn't a will in place. And his wife had suggested reasonably that he prepare a will. And they both were older. And this at a time when you don't live to extended ages. And so it seemed like it was something that was going to happen soon. He had a lawyer. There had been discussions. And so the prosecution's case hinged in part on just a calculating decision that if action wasn't taken and dad died first, that mom would inherit, the stepmom, the evil stepmom, would inherit a substantial part of the estate, and maybe all of the estate. Remember, by will, with adult children, there's no obligation to provide for their support.
Yeah, like you said, at this time, Lizzie's 32. She's an adult.
Yeah. So there was something at risk, and especially if Andrew, the father, was unhappy with this daughter, if not both daughters, this daughter. So it could have been that Lizzie foresaw that one way or another, she may be cut out of inheritance. That, remember, she's living on her dad's money at this point, and for that supply to be cut off would be devastating for her. So that painted a picture where the prosecutor felt that there was a basis to go forward, but from a forensic standpoint, it was shaky from the outset, meaning that there was no murder weapon that was ever actually found, which is strange. How could the murder weapon actually disappear? There was a couple things that they thought might have been a murder weapon, but there wasn't confidence by any means that there was that they found what was actually used as a murder weapon. But even more important, there was no connection to her of a murder weapon. Today we would look for some evidence on like a rifle that was used in a shooting. They'd look for evidence of fingerprints or something. Fingerprints existed, incidentally, forensically at the time, as something that actually Edgar Allan Poe in a story, actually, many argue, introduced the idea of this, where you could use fingerprints to find a murderer. And this is a little bit apocryphal. I suspect that forensic science would have gotten there, but apparently, after this story, suddenly the idea caught the interest of investigators around the country. It's a side story. Maybe we'll do. Have we done Edgar Allan Poe, Justin?
We have not.
We have to do Edgar
on the
Allan Poe.
list.
But we'll put that on the list. I'm sure he had an interesting estate, and he was interesting, period. And incidentally, Edgar Allan Poe would have been a good candidate for this Halloween show. Why don't we save it for next Halloween?
Put it on the list.
Yeah, let's put it on the list. We have such a long list. So anyway, in this case, though, the prosecutor felt that there was no evidence of someone else coming in the home, and they just felt that, she has to have done it. And there was some pressure to figure out who committed this horrendous crime. I mean, it just shocked this community of Fall Creek, Massachusetts, that they had never had a crime like this.
No.
Certainly not in recent memory.
And with such a prominent family, a well-to-do family, this is happening.
So you can imagine there was pressure on the prosecutor. But at the same time, they knew that the case was going to be difficult from day one. The best thing they had was that in the preliminary interviews, there were some inconsistencies in her testimony. We don't know exactly what those are, and I've not read the entire transcript of the trial. So I think those of you who have an interest, you can pull up the transcript. It's accessible. And I think that she... that maybe there was some issues with her timing when she came in the house, when she went to the barn, but that changed a little bit in the preliminary interviews because they didn't charge her until a week after the crime. So when the crime occurred in, what was it?
In
August?
1892, August 11th.
Yeah, in August.
She was arrested.
So she was charged, a week or so later. And you can tell that the prosecution didn't rush blindly into it, but they did form an opinion over a pretty short period of time that she was the only possible explanation, and so they felt, so it must be her.
She was emotionless too. There was not a lot of feeling. I mean, you just lost your father and your stepmother. Even if you didn't like her, you would think she would at least felt something for her dad.
No, her personality was that she wasn't that expressive and emotional anyway. But apparently she testified well, meaning even though I'm sure it lacked the emotion, but still it seemed credible. Now, keep in mind, this is a jury of men.
Yes, because they didn't really think
you
a
couldn't
woman
let
could
women
do
on
such
the
a
jury
thing.
at the time. And so some think that the men tended to stereotype her in her nice voice, and in her demeanor was appropriate. There's nothing inappropriate about her testimony, apparently. She wasn't shaken because she couldn't be shaken with testimony with evidence because there was no evidence other than these facts we've talked about.
Yeah, they didn't even find any blood
on her dress. Although there's evidence something had been burnt.
A dress
had been
and
put.
There was I think a reason that why there was blood on the dress. I had heard a rumor that it was just her, girly thing.
Yeah.
So that.
Unfortunately, those of you who really want to get into the details of this from a forensic standpoint, this is not the show. and so we've not studied this as much as I know there's great material out there. But we do want to dwell on this topic long enough to be able to talk about what happens thereafter in a more illuminated way. So the trial lasted about 2 weeks, or at least the judgment came 2 weeks later. And I assume that the judgment of not guilty came shortly after that they concluded. So it was a couple of weeks after the trial. Trial started in June and ended in June. So it was 2 weeks, I think.
Yeah, June 5th. She was acquitted June 20th.
So it's interesting. This trial, came along Fairly quickly. August, the crime occurs.
And then
You have the trial in June.
months later. Yeah.
So I think that this is a case where there was pressure to bring it, and yes, history has judged Lizzie as being the one who did this murder. By implication, on this show today, we're suggesting that we think that's the case too. But really, I can tell you as a lawyer, and I think you as a citizen, given the facts as we just kind of summarize them, it is appropriate that there's the risk that somebody who committed the crime goes free than to have the possibility that someone who's innocent is, there's the death penalty.
Yeah.
And women were executed as early as, in the assassination attempt on Lincoln. There was a lady, it was controversial at the time, and she was hung. So when female murderers were hung, it didn't happen a lot. But I suspect under Massachusetts law at the time, there's a good chance that would have been what would have happened. And I think that the men struggle with that. But even putting aside those gender-related things, I think that, the standard beyond a reasonable doubt, that standard calls for, think about it, not eliminating all possibility of guilt, but having we'll assign a number to it. Call it 97% confidence. Call it even 90. Some would say 95% is too low if we were looking for a number of confidence. This is a statistical phenomenon we use in all sorts of things, levels of confidence. It's actually a technical term, and it's used in making all sorts of decisions all around us where you assign a number value. And if you can't get above a confidence level of, say, 95% on some things, you do or don't do it, depending on what the issue is. And you don't hear this. I've never read about a percentage being assigned to this standard of beyond a reasonable doubt, because I guess they think that it's so squishy that they don't want to introduce that as a standard for judging people in court, and juries having to deal with that sort of statistical analysis. I get it, but for purposes of thinking about this case, let's think about what should that percentage be. 95% seems low. If you think about it, you may think, well, yeah, but 95% means that there's a very, very good chance they did it. But it means 1 out of 20 people would be wrongfully convicted.
Yeah.
1 out of 20 people. So if you think about what is the standard of confidence that beyond a reasonable doubt should be, especially when somebody's going to be hung, I would argue 95 is too low, 97, 98. So let's call it, for the sake of discussion, 97%. And many of you would say, no, that's too low. It needs to be 99. And maybe it should. But if it's 97%, do we believe on the facts that we've just discussed and what I think is fairly fair to the prosecution? Do we think that's enough to send somebody to the gallows? Just given these facts, do we think that gets to 97%? Think of all the things that could have happened. 97%. So my point in dwelling on this is to say that I think that the jury did the right thing, even though they may have been affected by gender and things of the time that wouldn't exist today. I really think it was the right decision. The alternative is to think that she would have hung and been innocent with no witnesses, no forensic evidence, just the fact that she was there, her testimony, she got some things wrong. So
that wouldn't have been
anyway. So let's move from the talking about those facts to now what about the estate? Now we've already tied it in with the fact that it probably was, if she's guilty, and I do think, let me be clear here, I think it's more likely than not. So if I'm asked, if you give me a standard of how do I bet this on a bet, a gamble of some sort, clearly, Las Vegas odds, these odds makers who look at every factor, definitely the odds would have been in favor of guilt.
Yeah.
So I want to be clear about that. I could probably get to 75% confidence or more that she did this. So I'm going to assume as we go forward here that she's the murderer. I'm just saying that she shouldn't have been convicted for the murder. So why would she have done this? Well, we gave the reasons that we think it ties in with money.
Yeah, money.
And throw in for good measure the hatred of this woman.
Yes, the stepmom.
Yeah, the evil stepmom will say. Uh, so, so when you look at also the discussion about having a estate plan going into place, and you can be sure this is the sort of thing that we find very credible, that there would have been discussion, certainly by the Abby, for Abby to be saying to her husband, we need to have,
Yeah,
you
for-
need to have some estate planning
Yeah,
in
for
place.
Abby's future, because there was only, I think, what, 6 years between husband and wife, but
Yeah.
still, I mean,
Yeah.
she probably wanted to feel more confident as
Yeah.
they aged.
So, and I think that's true. So I believe that this man who is a planner, we have, as a matter of fact, what's odd is he didn't have it in place at the time.
Mhm.
Some have said there was a will at one time and that he later decided that it didn't reflect what he wanted to do and dispensed with it.
Well, his daughters probably got old. Well, with age. Now they're adult women.
Yeah.
They might not need as much as they would if they were little girls still.
That's right. And no one found a will. So whatever that will was had been destroyed by him years before. But the wife, certainly Abby, should have been saying to him, you need to get this done.
Mhm.
And so if we make the assumption that that would have happened by such a planner as this man,
Mhm.
this very stolid, responsible, hyper responsible person, then maybe Lizzie did feel jeopardized.
Mhm.
And that could have been what spawned it. And also it may be that she felt that maybe this woman was going to unilaterally try to persuade their father to exclude Abby. It might be that she felt that Abby was actively campaigning against her in her father's judgment. And that could be something where she just felt that if she didn't act, that Abby was going to so influence Andrew that
Mhm.
that Lizzie would have been perhaps excluded for that reason alone.
So that would really make a person in today's world, if you're doing your estate planning, maybe don't let your children know about it. I
Well,
don't know.
I think
maybe
that
don't talk about it out loud.
I think there were sparks, probably going on in those latter days.
Mhm.
And some incidentally we know would have included Andrew and Lizzie. So um the thing is that Emma did not step forward and provide any
Mhm.
clear window into what was happening in the house. So it's still opaque the inner reactions, the inner relationships that were going on in that
Mhm.
family in the last year or so. Emma could have sank the boat of her sister.
Yeah.
I suspect that she knew things that would lend credibility to the charges, but we never saw that come forward. So Emma was predictably and behaving as she did, and maybe even not feeling 100% certain herself. She probably had a lot more confidence than we could have from the outside, but maybe she had doubts.
Yeah.
But she had enough confidence about whether she did it that I think her confidence level would be above my 75%.
She just kept her mouth shut so she'd get half the inheritance, right?
Well, actually, if she spoke up, she probably would have gotten more. Well, no, and we'll talk. That's a good transition point. So what happens? There's no will in place. So you have two daughters, the only heirs left to inherit. So at the time, it was pretty straightforward that would be what would happen. Now, the only issue became that no one was sure the order in which these two died. Now, if you think about it, the order of death is an important question.
Yes, and that was just up at the Gene Hackman when he passed away.
We
he and
did.
his
We
wife.
talked about that
Mhm.
issue. And now we have laws that deal with simultaneous death. In fact, there's a law now that's been
Mhm.
adopted in some form by virtually every state, and that's the Uniform Simultaneous Death Statute. And as the name implies, it's intended to address a very real problem. I mean, what happens when, as regularly does, when you have two people together, for example, a husband and wife,
Mhm.
the best example, and they're in a car accident, they both die, or some other calamity occurs, but it's not clear technically who died first. Now, if you think about what is probate based on, well, it's based on when somebody dies and at the moment of their death, who is alive that should be eligible to take, either by way of intestate succession, meaning no will, or by way of a will. That's the essence of what probate is about. What happens if somebody might have lived, say, 30 minutes longer than, we'll make it easier. We won't make it 2 minutes, although there are those cases. But let's assume it's clear that it was may have been an hour, we'll say. So in those cases, so two people died. Let's say they were on a trip, they were hiking, and all we know is their bodies were found 6 months later. And it suggests that one person probably lived several hours longer. We'll throw in a fall that occurred. So it wasn't that someone lived a week longer. It was that a fall occurred, but clearly because of the injuries, we believe one person probably died before the other. Well, if there was no statute to intervene on the principles that even you as lay people recognize, then if we believe one person died first, then everything goes to the other person who's now dead. But it means there would still be, you would probate the first person's death, which, think about the inefficiencies of this, but this is the way it happened at one time. So you would have a probate that would go on about the death of the first person, validity of their will, who's entitled to inherit, claims about undue influence in creating the will, claims about undue influence in the person, in their care or cause of death, whatever they may be. There'll be all that. So let's assume that's a year of probate and hundreds of thousands of dollars easily. So then now we go to probate the second person who died an hour later. Because remember, they now rightfully, if the will was valid or is intestate succession, now this other person who died an hour or 2 hours later is now they're the owner of that. So we have to move on to their probate. And remember, the first probate had to be completed before you do the second probate.
So it could be a while.
So we have another, what could be years of conflict and litigation and all the same things that we know can go on in probate. So you can see how crazy. Now imagine that there were 4 people on this hike and that they had relationships, a husband, wife, and children, and they're all dead. And so it looks, they didn't die at the same time, but they died
they were
within,
all together. Yeah.
they died within hours of each other. So if you didn't have some special statute, think about how silly this would become. You would go from one probate to another, working through this entire family to figure out who ends up with these assets. So not surprisingly, there's relief. However, at the time that this occurred, 1892 was the death, and 93 was the trial. So in this day, there was an effort to discover who died first, and it was relevant. And as a result, while there were mechanisms to try to avoid the insanity of what I just described, it was entirely up to what was called common law. And often there was no remedy. So they would go through the craziness I just described. But at this time in Massachusetts, the first question became, who died first? And if we can at all know who died first, then we're going to go ahead and recognize that person is having left the assets to their surviving spouse, kind of like I just described with the hike scenario. So it could have been that crazy and threatened to become that crazy if in fact there hadn't been a deal struck. So what would have happened if we knew that, say, the dad died first? Well, that would be a problem because think about it. That means that the wife, even in intestate succession would have inherited some of his assets. Not what would have happened today, but she would have gotten, it's called a right of dower or a dower share. So she'd have had a lifetime estate in the home, could have been at least a third, could have been more than a third. She would have probably gotten his personal property, which includes a lot. Remember, personality doesn't mean just tangible things. It means financial things too. She might have had a claim to some of that. Now remember though, the daughters, this is intestate succession, so there's no will. So there's a statute in Massachusetts at the time who says who gets what. So the daughters clearly would have gotten as much as half, more than half actually. They would have gotten more than half, but still it's a big chunk to disappear. So is it coincidental? And are we imputing too much forethought and cunning to Lizzie to say that she chose to go upstairs first and kill the mother versus killing the dad. Stepmother, sorry, versus killing the dad. In other words, the fact that the evidence suggested that the mother was killed first, stepmother, that meant that whatever she would have had, she had no children of her own. So that would have gone to her husband.
Yes.
So now she did have some relatives who would have a claim to some of her things, because under intestate succession at the time, a wife, which is treated different from the husband, very sexist era, but before the 20th century. So it meant that her personal property, again, we don't know what was in her name. It's true that probably most things was in her husband's name, but still her personal property, again, including financial assets, gold, silver, anything that she had, could have gone to her relatives. But her husband had this right of, it's called courtesy, C-U-R, not courtesy as we normally spell the word. So C-U-R, courtesy. That means that he had a right to all of her real estate, any real estate she owned for the balance of his life, and certain other privileges. So husbands had a bigger advantage. But anyway, as these other things, since she had no blood heirs except for these cousins, then it means that most would have gone to her husband. The vast majority went to her husband, but still there's some that floated out there. But by far the better scenario, clearly, for Lizzie, would be for her stepmother to die first. That takes care of all the big assets, anything major.
Yeah,
and
the
then
competition.
then go down and kill the dad, who, had she not killed the dad, then there was what would the dad do?
Yeah, the possibility he could have been like,
so the
daughter,
do we think the dad would have written her out of the will for killing his wife? So we know that if she really wanted to make a move here to maximize her inheritance and to assure that it occurred, in a safe way for her future, then it could be coincidental, but it is true that she did it the correct way. You know what I mentioned a while ago, that we would think in a normal scenario like this, where if this is, a crime of passion, where she just flew off the handle one day and just went nuts, and maybe there was an argument, and she runs upstairs and kills this woman, and she's mad at her dad too. So she runs back down and kills the dad. You wouldn't have this elapse of sufficient time between the two murders as to suggest some sort of planning and forethought. So I'm just throwing this out there. I've not read this anywhere. So it's speculation, but doesn't it seem that if she really were motivated to maximize her inheritance, that the way to do this would have been to go up, be sure she killed the stepmom first, then wait for there to be sufficient time and evidence to develop. Then she goes down, and she does this at a time that her dad's sleeping on the couch. So there's enough time for her to not have to act immediately. This assured that under existing law at the time, that she would inherit, that the two of them would inherit everything. Now, there's a little bit of a qualification of that, which would have been no problem in her mind in developing this plan, was that assuming she was fully informed, and this is a big assumption, so it is imputing a lot of deviousness and cunning to her, but she would have to deal with some of the assets potentially being claimed by these very unhappy relatives, whose
lost a relative,
cousin or whatever was murdered, and I'm sure all of them was confident it was Lizzie. So naturally, they're going to do all they can to challenge this opinion about who died first, and then to claim anything technically that they might have been able to claim, even if their mom did die first. But remember, this is a little cloudy, how forensic being as primitive as it was at the time. So the relatives did exactly what you would think they would do. They created a dust up. They were clearly going to challenge this order of death, and it was just enough, even though I think that ultimately Lizzie and her sister would have prevailed, but they decided to buy it off, and so they paid what one report suggested was $5,000 bucks, not much out of 300,000.
Kind
So
of just go away money.
yeah, go away money. So supposedly there was a settlement. We don't know how much. Could have been more than 5,000, but what I read was is around 5,000. Enough to send them away, because if they lost the fight, then clearly they would get even less, because we remember this was stuff that was in her name. So that might have been very little, you know, in
Mhm.
terms of bank accounts at the time. They just didn't put those in people's names like that. But she would have had personal property, tangible things.
Mhm.
So
And it would have taken more time, and you never know. Lizzie, perhaps other things would have come out with her. She
yeah,
might have lost her cool.
yeah, and right, and so there'd be uncertainty, and
Mhm.
so the fact that there was a deal done, and it was $5,000. If it was $5,000, it tells me that what they knew they would get would be less than five, and so a larger number was offered to incentivize them to not keep going, in the hopes that they can challenge this order of death and perhaps come into more money, a larger inheritance. So now let me talk about a couple of things that would have changed this outcome, and these are relevant today, tying it in with what is there in terms of a learning opportunity here. I don't want to assume that any of you would do estate planning by murder and mayhem, but it is interesting to know what would be the results in today's world where this happens. And of course, many of you are familiar with. Well, let me first talk about the Uniform Simultaneous Death Statute. I mentioned it, but I want you to understand a little more about how it works. Now, it solves all these, what you could imagine would be horrendous problems and wasteful uses of the court's time and people's lives, and money going to lawyers. So the Uniform Simultaneous Death Statute has been adopted, as I said, in almost every state. And the standard form is 120 hours. So now in estate planning, you can opt out of it. You can say in estate planning that you want a strict order of death to be applied. I mean, it's not as
Mhm.
if you can't do that now. The law will permit you to do it, and though you invite all these potential problems I've discussed, but far and away, most people accept that they want a provision that has 120 hours. So think about it, that's 5 days. So the whole idea is not just to pick up those things where, was it an hour, was it 3 hours,
Mhm.
to get rid of that argument, but it's really, you really care if somebody died. Say there was a car accident, and
Mhm.
one person dies in the accident and the other person doesn't die for 4 or 5 days later. So in those cases too, you didn't want two probates.
Mhm.
It would just be a terrible waste of the family's
Yeah.
resources. So this is a thing that should have come much sooner, and the statute, be assured, is out there now. And unless you choose to invalidate it or to exclude it in your will, then it's going to govern. So that's one factor to understand about what happened. The other, much more interesting, I think, is the Slayer statutes. Slayer statutes didn't come into effect until really probably the second decade, in a big way, until the
Mhm.
second decade of the 20th century. However, it's funny, they started emerging in very early years. There was some common law. So let me give credit to, the Napoleonic Code, and even earlier medieval stuff, where they recognized if somebody is evil enough to kill, they shouldn't be able to get benefits. Uh,
Oh.
so there was this rough concept that we inherited from English common law. So in various states, it took various forms, but it was very irregular, very qualified, and not reliable for purposes of excluding people who did bad things. So it's funny, and that just 3 years before this murder occurred in 1889 was the decision that set rolling what
Mhm.
became Slayer statutes that exist in every by statutes exist in every jurisdiction now. They're out there. So in some form in all the 50 states, there are statutes that deal specifically with what are the circumstances when you're excluded from inheriting. So that's called a Slayer statute. Uh, in 1889 in New York. Now, New York and California, you should know, are far and away the most influential jurisdictions
Yeah.
on the law in America, for good or ill. And I would say just as much ill as good. But it just is a fact that a lot of new law that emerges from California or New York. So often in law school, students learn and judges will make reference to what's happening in these states as bellwethers for what may be coming to your state or to middle America states. And New York had, in fairness, also had some of the great jurists in history. I mean, these were scholars, they were thoughtful men. So that's part of the reason, especially New York. So there, it's called the Court of Appeals, but it's the equivalent of the Supreme Court in every other state. In New York, the first level of appeals is called the New York Supreme Court, and then the highest level is called the Court of Appeals. Go figure. But anyway, so the Court of Appeals took on a case in 1889 involving a 16-year-old boy that killed his grandfather because he wanted to come into his inheritance sooner than he otherwise would have, and his grandfather had created this will. And he had been very explicit about how he wanted his grandson to have these things. And so his grandson thought, well, why wait? So he poisoned his grandfather. So, but the lower courts had ruled based on the common law at the time in the state of New York, which had concepts relating to, slayer ideas that you don't want to reward this sort of wrongdoing. But the way it existed, it wouldn't apply if there was a will in place in which somebody specifically said that they wanted their son to have these assets. And I don't know whatever the other terms were, but clearly the law as it existed clear in New York up to that time would have, and in fact did, get an order on the lower level courts that this grandson still gets the money. So had the Court of Appeals of New York not overturned what was clear precedent in New York at the time, and I suspect in many other states, that because it was so flimsy, the law that exists before then, and so qualified, and with all these exceptions, and New York's being one where there's a clear statement in a will that you want a person to get something, that should be honored, recognizing the sanctity of wills. So it had to go all the way up to the Court of Appeals, but this big change, it was a sea change for the entire country, occurred in 1889 with this decision. It was Riggs v. Palmer, and that changed the law in New York forever, and soon other states followed, and then the statutes started being passed thereafter. So it's funny that this law relating to slayer statutes that had occurred just a few years before. So that probably wouldn't have stopped in Massachusetts. We don't know, because there wasn't a will. So there was a common law in Massachusetts regarding this sort of thing, but it had a lot of holes, but it didn't come into play because she wasn't convicted.
Yeah.
And virtually all of these statutes require conviction. So keep that in mind. One other thing I'll point is that even though what I've said to you seems simple and straightforward about slayer statutes, it's really much more complicated than it seems. In 2004, there was a case in Massachusetts, a very prominent case that has been influenced other jurisdictions. This was a case where the children of the murderer were to inherit from the murderer who killed his father. So we're talking about the grandchildren of the victim. So that's not so straightforward. Would the grandfather who died at the hand of his son, would he not have still wanted his grandchildren to be eligible? So that was the issue in this case in 2004 in Massachusetts, which I don't have the case in front of me. But anyway, this case said, no, grandchildren cannot inherit. So, I mean, it means the ruling in that case was no family member can benefit from the actions of this person. So this is just one of the issues. Another that comes up in this context is assisted suicide. It's killing another person. What one could argue that should be black and white. They participate in killing the other person. We know that there's a rule that forbids that. So that's an issue. Another issue is, what level of culpability? What if it's a crime of passion, meaning somebody was upset at the moment, committed the crime, and even the courts decided that this person shouldn't go to prison for long. They were just in a state of whatever, but it was an intentional crime and it was murder. And should we apply it the same way? Well, most states say yes. Some say no, there should be premeditation. There's another level of what about negligent homicide? What if somebody's reckless? They're driving, drinking, and they kill their dad in the seat next to them, and they inherit. Should they inherit? Some states say No. Others say negligent homicide, yes. So it's even though thankfully we have SLARE statutes now, and it is important to have them for cases like this, even though it didn't come into play, but it still raises a host of other questions that different states have dealt with differently.
It sure does. It'll blow your mind.
So,
My
yeah, this has been an interesting discussion. We could talk more about it. Let me give you a heads up that we're going to actually pick up with a part 2, and we're going to pick up with the balance of Lizzie's life. Remember, she goes on to live 30 something years after this. And then her estate, which she did have a will, but we're going to talk about that. And there's some interesting twists and turns regarding that. But it probably won't appear in our next show, because the way we do this is we try to have these completed and ready to post by Wednesday of each week. And we know that if we do this show and then we had another one scheduled. So anyway, it's going to be like 2 weeks away. So it'll be part 2. It won't directly follow this, but I encourage you to watch it because I think it's very interesting. The rest of Lizzie's life, as well as what happened with her estate, which raised some issues in and of itself.
And hopefully it gets everyone to thinking about how you need to plan. And especially if you have blended families, especially,
doesn't?
get it all written down and do the right thing, because it could be, helping your children and anything that could happen to you.
Yeah. There's definitely things to learn in this case, but not as direct as usually is the case. So I won't dwell on those. Plus, because we're doing this live, and incidentally, we've really enjoyed it. I hope you like this. Let us know if you like this format. But we didn't want to make this any longer than I notoriously make it anyway. This is all my fault. Justin, I aspired for 30 minutes? Best laid plans. Anyway, but we enjoy doing this, and we'll do it again. Let us know if you like this. We really want feedback. And incidentally, keep Cordell in mind, not just for domestic relations, but also for estate planning. And yes, if you mention this show, we continue this program where we're doing a 15% reduction for people that retain us for estate planning if you mention the show. So we would like for this show to generate some income, but whether or not it does, we really enjoy doing the show, so I continue doing it, and I hope you find it beneficial. So this has been another episode of Life's Third Act. Till next time, take care.